In Washington, the Trump administration announced yesterday it will ask the Supreme Court for an expedited review of a federal appeals court ruling that invalidated most of the president's reciprocal tariffs. Speaking to reporters in the Oval Office on September 2nd, President Donald Trump confirmed the government would file its request tomorrow, seeking a swift decision from the High Court. The move comes less than a week after the U.S. Court of Appeals for the Federal Circuit, in a 7-4 ruling, struck down the tariffs. That decision, issued on August 29th, consolidated two major cases: VOS Selections Incorporated versus the United States and Oregon versus Trump. The tariffs in question were implemented by the administration as a tool to counter what it described as unfair trade practices by other nations, imposing duties on foreign goods equivalent to those placed on American products. However, the appeals court found that the administration had largely overstepped the authority granted to the executive branch by Congress under existing trade laws. The administration's appeal to the Supreme Court will argue that the president's actions were well within his constitutional and statutory powers to manage foreign commerce and protect national economic interests. The legal battle has created significant uncertainty for businesses that rely on international supply chains, and an expedited ruling from the Supreme Court could provide clarity sooner rather than later. The administration's legal challenges are not limited to trade policy. The Department of Justice has now filed a lawsuit against the state of Illinois, challenging its policy of providing in-state tuition rates to undocumented immigrants. The complaint, filed in the Southern Illinois U.S. District Court, names Governor J.B. Pritzker, State Attorney General Kwame Raoul, and the Board of Trustees for the state's university system as defendants. The Justice Department argues that Illinois state law directly violates a 1996 federal statute. That federal law stipulates that undocumented immigrants cannot be granted post-secondary education benefits, such as lower in-state tuition, unless those same benefits are made available to all citizens of the United States, regardless of their state of residence. In a statement, Attorney General Pam Bondi said that Illinois laws, which grant residency for tuition purposes regardless of citizenship status, are in blatant conflict with federal law and the Supremacy Clause of the U.S. Constitution. The lawsuit follows a recent development in Kentucky, where state leaders agreed just one day prior to comply with the federal law, ending a similar policy. U.S. Attorney Stephen Weinhuft characterized the Illinois policy as part of an apparent desire to win a race to the bottom as the country's leading sanctuary state, signaling a broader federal effort to enforce immigration law at the state level. While the executive branch pursues legal action on multiple fronts, lawmakers on Capitol Hill are moving forward with major legislation. The Senate yesterday advanced the annual defense policy bill in a strong bipartisan showing. The fiscal year 2026 National Defense Authorization Act, or NDAA, cleared a key procedural hurdle on a vote of 84-14, setting the stage for further debate and amendments. This year's version of the bill authorizes nearly $925 billion for national defense. That total includes over $878 billion for the Department of Defense and another $35 billion for the Department of Energy's nuclear weapons programs. The legislation is focused on core Pentagon reforms, particularly its long-standing failure to pass a full financial audit. It also includes a pay increase for service members and a notable extension of the Ukraine Security Assistance Initiative through 2028, increasing its authorized funding to $500 million. This year's process stands in contrast to more contentious debates in recent years. The bill lacks the divisive provisions targeting so-called woke policies at the Pentagon, which became a major sticking point for House Republicans. Senate Armed Services Committee Chairman Roger Wicker stated that the U.S. is facing its most dangerous threat environment since World War II, a sentiment echoed by his Democratic counterpart, Senator Jack Reed. However, a significant gap remains between the Senate's bill and the one being prepared in the House. which is expected to authorize a lower total of around $848 billion. The two chambers will eventually need to reconcile these differences in a conference committee. While the Senate focuses on the massive defense authorization bill, the House of Representatives has taken decisive action on another national security front, the opioid crisis. Lawmakers there overwhelmingly passed the Stop Chinese Fentanyl Act yesterday in a 407-4 vote. The bill, introduced by Kentucky Republican Andy Barr, seeks to give the U.S. government more powerful tools to disrupt the flow of synthetic opioids from China. It would amend the existing Fentanyl Sanctions Act, specifically authorizing the president to impose sanctions on Chinese individuals and entities knowingly involved in producing, selling, or transporting fentanyl, its precursors, or related equipment. The sanctions could include freezing assets and blocking financial transactions. The legislation also targets those who finance such trafficking or refuse to cooperate with American counter-narcotics efforts. In a statement, Representative Barr said the Chinese Communist Party plays a prominent role in every step of the fentanyl crisis. This legislative push comes as federal agencies continue to identify China as the primary source of the precursor chemicals used by Mexican cartels to manufacture the vast majority of fentanyl that enters the United States. This remains the case despite an official ban by Beijing on fentanyl exports to the U.S. in 2019, as the trade in precursor chemicals continues largely unabated. In other news from the House, the Oversight Committee has taken a significant step in its investigation into the case of the late financier Jeffrey Epstein. The committee yesterday made public a massive trove of more than 33,000 pages of records related to the case. This release is the direct result of a subpoena issued by Committee Chairman James Comer to the Department of Justice, compelling it to turn over its files on Epstein and his associate, Ghislaine Maxwell. Maxwell is currently serving a 20-year prison sentence for her role in aiding Epstein's sex trafficking ring. The newly released files include a wide array of documents, as well as video clips that appear to be body camera footage from police searches connected to the investigation. This release is part of the committee's broader inquiry into the handling of the Epstein case by the Justice Department and the circumstances surrounding Epstein's death in a New York jail cell in 2019, which was ruled a suicide. In a statement, the committee noted that the Department of Justice has indicated it will continue to produce records in compliance with the subpoena. The DOJ is also working to ensure that the identities of victims and any sensitive material related to child sexual abuse are properly redacted from the public releases. The Oversight Committee's investigation is ongoing, with deposition subpoenas also having been issued to several former officials, demanding their testimony on the matter.